Hi, everyone. My name is Bhatt. I'm a partner at Major Lindsey and Africa within their associate practice group. MLA is the world's largest and the nation's top-ranked legal search firm, and I'm here today to talk to you about litigation. So you want to be a litigator? Well, that's great news. In 2023, litigation is actually the most currently the most in-demand group, especially for entry-level positions. Now, litigation attorneys, what they do is they help their clients resolve disputes. If disputes are not settled by negotiation, then it can be concluded either by court litigation or an alternative form of dispute resolution, usually an arbitration or mediation, which obviously is going to be less costly, out of public view, and a lot faster. Disputes can concern anything under the sun, whether it's unpaid bills, breach of contract, problems between landlords and tenants, infringement of IP rights. The list literally is endless. And since the recession, many general litigators have become increasingly involved in conflicts, financial related conflicts, whether it's securities, white collar crime, or even bankruptcy scenarios. There will be some litigators that'll concentrate on a specific type of claim, becoming an expert and making use of particular industry knowledge. And then there's going to be others that are going to remain generalists, especially in the trial arena, applying all of their legal experiences to all manners of cases and clients. I'm not going to go into the day-to-day of what a litigator does today, because we've actually seen a lot of it through pop culture, media, whatever it may be. We've seen it on TV. You've also been involved in moot court. You've been involved in probably pre-trial types of work within your law school. You can Google it. You can look that up. I think what's more important is for us to talk about the different types of litigation practice areas that you'll encounter in a law firm, because more often than not, you're going to be required to specialize early on, and it's hard to change between the different types of groups, especially if you're in a bigger city like New York. So it's important for you to think about and appreciate the differences and what's going to be expected of you as you kind of determine and navigate your career path. Let's start with commercial litigation first. Commercial litigation is the biggest practice group of any litigation group at firms, and that's because it's so broad. To put it succinctly, it's advising on resolving business disputes that arise from your client's most important relationships. That means figuring out the best outcome for the client, a lot of risk analysis, figuring out whether pretrial negotiations, settlements are necessary, or if you're going to go to trial. It's really hard to determine how many cases are going to go to trial, even despite intense planning. It's a really broad practice, and relationship with various industries are essential to build business, which is something you should think about if you want to make partner. Now, commercial litigators are consummate generalists. They're always learning something new and are never expected to be an expert at anything. There are still ways to specialize, whether it's in trade secrets, class actions, etc. And each firm is different. Some firms are more trial-oriented, especially for that bet the company type litigation. One question you really want to ask yourself is, how important is the commercial litigation practice to this firm? Commercial litigation is a quintessential adversarial practice, and the interactions between the parties can be tough. Attorneys rarely concede a material point in this arena, and negotiations can get pretty intense. This means you spend a lot of time drafting arguments, and some of them you might suspect are a waste of time. But the reward is victory. So you must get satisfaction from winning at any cost, or whatever makes sense for you. People who like this practice really appreciate the intellectual diversity and the fact that attorneys run the show, not the clients. The clients need you as the expert. People who are dissatisfied with litigation typically are not excited about the fact that matters can last for years. The enormity of litigation practice gets a lot of people to walk away from it. And overall, the practice can feel destructive rather than constructive, and it can be difficult to predict your schedule. You can spend hours, days, and weeks working on items that you feel might not eventually matter, especially if it gets to settlement. The second biggest practice that you'll encounter at firms is white-collar litigation and investigations. This is a really narrow practice area and is different from other litigation practices, which tend to be more civil in nature, if not in tone. Basically, it's the representation of corporate clients and their officers, directors, employees, boards, and board committees in cases and investigations typically brought by government agencies in the US and abroad. Specifically, it refers to a really broad range of finance-related offenses that can be subject to regulatory investigations and enforcement actions. It covers a range of conduct that can implicate antitrust, the Foreign Corrupt Practices Act, or FCPA, anti-manipulation, and fraud statutes. Oftentimes, white-collar laws often concern practices of global institutions, and these investigations require a lot of cross-border proceedings before a lot of regulators. Also, criminal rules differ from civil rules. The community of white-collar practitioners is usually very, very small, and most of them all really know each other, and for the most part behave with a higher degree of civility than general litigators. Day to day, it is similar to civil litigation when you're in the litigation context with research, drafting, factual development, arguments, but you have a lot more and significant client contact. This is a really tough practice area for associates because there's little leverage. Clients whose lives are on the line want to work with the partners, not necessarily with the associates. Also, the usual path to become a leader in this field is to come from government practice. So the practice contains many senior attorneys that started out as a law firm associate, went into government, and then came back as a partner. Also, client relationships tend to be very, very close. Now, in white collar, as in civil litigation, the attorneys run the show rather than the client. These attorneys have to like battling the government. You want to see yourself as sort of the fixer, called in the last minute to clean up a really bad situation. Crisis management is a key component here. A lot of white-collar attorneys have to accept that sometimes you have to defend guilty individuals and companies, so you must be comfortable with moral conundrums in this space. In addition, because of the high stakes, clients are going to require 24 access to you. It's a high-stress practice as well. Finally, there's a lot of travel. It is very highly sophisticated, but you might be shipped off to China for a month to do a bunch of investigations for a company. You do get a lot of interaction with people, though, and regulatory investigation and enforcement work often comes hand in hand with civil litigations concerning the same conduct, so that expertise can come in handy on the civil side as well. In terms of character traits that make a really good white-collar litigator, you need to be inquisitive above all else and have a desire to really figure out the problem, dig deep and gather and understand the facts of the case. If you're like that, then white-collar crime might make sense for you. Note that this practice is pretty academic in nature, and grades are really important in addition to clerkships and or government experience. So it's something you might want to think about if you are interested in becoming a white-collar litigator. The next biggest practice area, especially in New York, where I'm based and am an expert, is securities litigation. This is a type of civil litigation where attorneys represent individuals and corporations in securities class actions, stock drop cases, and derivative actions. They also perform internal investigations on behalf of corporate audit committees, such as whistleblower investigations. They represent audit committees, individuals, and companies in SEC investigations, advise corporations regarding director and officer liability insurance, and advise law firm corporate departments regarding disclosure questions. The day-to-day work involves most usual litigation tasks focusing on pretrial activity. Associates spend a lot of time drafting, counseling, interviewing clients, and on factual development. These cases can have intense discovery demands. Partners spend a lot of time on the telephone advising clients and drafting. Hours can be really long and cases can be really complicated. Attorneys who like this practice enjoy helping accused individuals. This is the closest you can get to doing criminal defense work without worrying that your client's going to go to jail. Client relationships with individuals and company management tend to be very close. These attorneys also enjoy working in various industries and learning about companies' businesses. People who don't like this practice are often frustrated because these cases rarely go to trial. Also, the actions can be frivolous, and often there's no meaningful plaintiff as it's a lawyer-driven industry. So the actions can feel biased. Defense counsel does a lot of work, and plaintiffs make unfounded allegations. So it is a big practice area. There's a lot of money in this space, but I do often hear from commercial litigators that I want to step away from securities and move to something that's more people-oriented in perhaps the white-collar context. So again, it's just another thing to think about in what type of person are you? The next biggest litigation practice group that we're seeing becoming even more of a thing these days is antitrust law. This is a hot button issue, and we're seeing this practice grow and grow, and we keep seeing all these mergers of all these big companies, and so it makes sense, right? Antitrust attorneys help companies navigate the restraint of trade issues, including those created by organic growth or acquisition. This practice is going to focus primarily on litigation, but there can be some counseling and transactional work involved as well. The litigation tends to be very high stakes for the companies and can be civil or criminal in nature. A lot of antitrust attorneys come from the Department of Justice or spend at least part of their careers working for state or federal government. These cases are often litigated against the federal government as well. This is a complicated area of law that is good for people who like very sophisticated issues, who want to learn about industry segments, and who like economics, market analysis, and intellectual property. This is a win for us nerds. It tends to attract very smart people. Antitrust suffers from the same challenges as any general litigation practice, with the addition that since you are litigating against the government, success rates tend to be rather low. That being said, you do want a really good antitrust litigator on your behalf to get you the best outcome or situation possible, which is why the rates are so high in this space, and many law firms have decided to really grow their practices in this arena. The next practice area, which is pretty big at a lot of firms, is toxic torts or products liability. We've all seen products liability. We've heard about that McDonald's case. I'm sure you learned about it in law school. These are, product liability practice is litigation involving the production, manufacturing, marketing, and use of a business product or service. It can involve anything from traditional products liability theories, such as design defects or strict liability, to antitrust and consumer class action claims. Toxic tort practice usually involves harmful agents such as asbestos, etc. People who like this practice enjoy the fact that there are many depositions and they're allowed to assume every role, from scientist to corporate counsel. Also, these attorneys feel they are essential to a company's business. The lifeblood of many businesses is the revenue from goods sold, and the product liability lawyers seek to protect that revenue flow. People who don't like this practice are frustrated because these cases rarely go to trial and typically involve graphic personal injury and death. Also, these cases are very document intensive, sometimes involving millions of documents, literally millions, and take a long time to resolve. In a lot of markets, these practices are also considered second tier. I understand that, but at the same time, I think some of this is very exciting. I've spoken to so many products liability attorneys that think it just gets a bad rap. It's a very exciting, interesting practice. And especially on the defense side, you are helping some of the biggest corporations help soften the blow of issues that they may have encountered. And on the plaintiff side, it can be really rewarding because you're kind of forcing companies to act in the manner that one wants them to. And so it's a really great way to regulate in some ways when the government perhaps is not in a position to do so. Finally, the last practice area that I want to discuss is probably the most difficult to get into, and that's appellate law. This appellate litigation is extremely prestigious and very hard to break into. The day-to-day work involves only legal research and writing. There's no fact development work such as discovery, depositions, etc. It's not necessarily as adversarial or time-sensitive as trial litigation. It's really great for introverts who want a predictable schedule. Pure appellate practice usually is focused in Washington, D.C., but there are some pure appellate practices in both New York and L.A. as well. Appellate work tends to mix with trial practice in other cities outside of those major metros. Now, these cases tend to be very morally difficult. A lot of appellate practices focus on tobacco-related litigation, especially. In this situation, the defendants appealed because they were hit with large damages because they did something pretty bad. Damage reduction cases can involve difficult arguments regarding how valuable a person's life was. Aside from damage reduction cases, questions can also be really arcane, like how does the Seventh Amendment apply and how would it have been interpreted in 1791 on a subject that it doesn't directly address? This is definitely work for big brains. It involves a lot of discrete projects that tend to be shorter than general litigation. In this scenario, again, if possible, if students are really interested in this, they should try to write for law review, obtain a federal appellate clerkship. Grades are really, really important. In fact, most appellate practices in New York especially, and around the country, if it's solely based on appellate work, they're not even going to consider you unless you have that federal appellate clerkship. So it's another thing that you want to think about as you move on with your career. So those are the major topics that I wanted to discuss today. I could go on and on for hours about this, and sometimes I do. But I wanted to just give you a quick overview of the types of areas. As you can see, outside of the major financial centers, you'll have litigation practices that cover the whole gamut of all this. But typically, if you're looking at a major legal city, whether that's New York, Chicago, LA, it's DC, you're going to have to decide what your major is. So think a little bit about what it is what you want to do with your career, and choose accordingly. Good luck. Thanks.